A very good evening to all of you all. Now, in continuation of our marathon, JIGL marathon, this is the second marathon that we will be taking. In the first marathon, we had covered considerable number of chapters. In this marathon, again, we will be covering 20 to 30 to 40 marks again. There will be one more part, that is the part 3, where I will be taking the 3 criminal laws all in one go, that is tomorrow. Okay. So before I start, can you let me know in the chat section whether I'm audible, visible, and if you're ready, just hit the like button. So waiting for you all because I'm going to cover a few more chapters, and you can see I'm covering the entire syllabus, not cut shorting anything. Every topic is covered. Okay, so you can check it out as well. So let me know in the comment section first. GTG in the chat box. Darshini, Maria, Evie, Vaishali, Kaushika, great. Great to have all of you all. Just those who are viewing, hit the like button. It just boosts my confidence to deliver even better lecture for all of you all. Clear? GTG in the chat box, and I will be telling what is the plan for today. Now, yesterday we had covered one part, okay, which was yesterday we had covered interpretation of statutes. Now, one chapter they have started asking, which is the General Clauses Act and how to read case laws. These are something new that they have added. Okay, great. Vaishali, Karthik, Darshini, Evie, great to have all of you. Let's start with today's chapter. So I have shared the notes of the chapter that I'm sharing now. I'll tell you which one it is. Okay, this is the General Clauses Act. In the last exam, they had asked it for around 6 to 8 marks. So I will quickly cover it for all of you all. You don't have to worry as well. Okay, and how to read case laws as well. So this is something new that they have added, and I expect all of you all to be there with me. Chalo. Let's start. Hi. So in this video, I will be telling how we can read case laws and how you can read bare acts as well. So first, talking about a bare act. Okay, what is the meaning of the term bare act? The bare act is basically the pure law which has been passed by the parliament. So a bare act contains the exact original text for law that has been passed by the parliament and the legislature. Now what happens is, even me and all the lawyers and the company secretary, we prefer reading directly from bare act. Why? Because we come to know that the real law. Why read someone author's book? They can make mistakes. So when we want to advise our client, we don't read any online text. We go to the law, the core law, which is called as the pure law or the bare act. Okay, it does not contain any explanations or any other thing. It is directly act what has been given by the parliament. For example, if I want to know about the criminal laws, I will obviously go directly to the BNS Act 2023, read the entire law. As experts, we would be able to understand it better. Similarly, if I want to understand Companies Act 2013, I will open the Companies Act, I will see section 1, 2, 3, everything given in order. So this helps me understand the act as well. So what is a bare act? A bare act is the exact original text as passed by the parliament. Now, what is the problem that people face while reading with the bare act? Now, obviously, the bare act is written in legal language, direct law language. So there are no explanations, simplifications. So you need to be at a certain level to be able to understand the bare act properly. Okay, so bare act is always given in technical and legal language. It is long, complex. Okay, it has several legal terms. Okay, the provision must be read as a whole, etc. So it requires patience, attention, and expertise to understand a bare act. So when we prepare the notes, we always see that we are covering the Bare Act, so that the students, when they go to refer the Bare Act, they find it very, very simple. Now, how can you read the Bare Act? What are the provisions and how can you read a Bare Act properly? The very first one is you read the chapters, how it is being given. Then you read section 1. Always the section 1, okay, in any Bare Act, whenever you read the section 1, it talks about the title. It tells what is the name of the act, what is the object of the act, the applicability of the act. Normally, and in most cases, section number 2 will contain the definitions. So definitions will be given, and then you will have certain chapters, and then you can read it. So this is how you have to read the Bare Act, okay? Break the sentences, understand it, and always read the updated version, because the law keeps amending from time to time. Now, the second part, after understanding Bare Acts, then we are talking about case laws. A case law is called in court called as citation. What it is called? It is called as a citation. Now I'm going to teach you how you can read a case law. After this you will be able to read, interpret and understand any case law. Let's understand, a case law can also be called as a citation. A citation means you can figure out in which year it was passed, who were the parties. If I want to locate it in any book, where I can go and locate it. So let's read, what do you mean by the term citation? So citation is a reference of a judicial decision. So it's a judicial decision, a case law. Normally, if there is a case law passed, for example, MC Mehta versus Union of India, I want to go and read the entire judgment of the case. So I need to know its citation, where I can find in which law book, which page number, which volume number I can go and read. Okay. So courts follow a procedure of principle of precedent. Now we had done something called as a precedent. Means what? Once a case law is there, the rule is made, then normally that rule is followed even in future. So if today I want to understand that what will be the judgment, this particular case is there. So I will see a similar case passed I have to go and read a similar case given in the past. I will read it, I will see what judgment was given, and I will understand this judgment is given, maybe the similar judgment will come in my case. So normally as lawyers, when you are appearing, and company secretaries, when you are appearing in courts, you try to figure out similar case laws so that you can substantiate your position and win the case. Okay, if I find a case law of Supreme Court, I know it will have a binding decision or authority on all the lower courts. So let's take and read a case law. Now I'm going to teach you how to read a case law. First I told you what is a case law. A case law is a citation of a judicial judgment. It is a citation. You can figure out what they have given, a citation or a reference to a judicial decision. Let's take an example. Now I'll teach you how you can read a case law. Maneka Gandhi versus Union of India 1978 1 SCC 248. Now imagine if I and you as a law student, as a student of corporate law, want to go to this case law exactly how the judgment was given. So what do you need to do? You will go to this case, Maneka Gandhi versus Union of India. This tells you the year, in which year it was passed. So I will go earlier. Nowadays you have everything online, so it is very easy to figure out and find the case law. But when online repositories or online systems were not there in place, then you had to go to the books, to the entire courtroom. In the courtroom you had to go to in the year 1978, you will see which all books are there in 1978. You will go to volume number 1. This will always talks about the volume number, because in 1 year also multiple cases are there and multiple volumes will be created. Then I will want to know in which case it is. So S means Supreme Court cases. So SCC means Supreme Court cases. Like that, there are law journals. We'll have to just know the name of the law journal. Or with a citation, you will say that where is a law journal here? You'll go in that, like here in this case, I will go to Supreme Court cases. It's a journal, volume 1 of 1978, and this refers to the page number. This always refers to the page number. So again, here when the Maneka Gandhi is being given versus Union of India. Now pay attention to this, okay? When they give you the word versus, means what? This one will be the plaintiff, okay, if it is a civil matter, and this will be the defendant or the respondent. You could call them as a plaintiff or the petitioner. Plaintiff or petitioner is a first party. In criminal cases, they will be called as complainant. And this guy, the second party, will be called as defendant, respondent in civil matters, and in criminal cases, they will be called as accused. Second, also, if it is an appeal, then the first party, whoever is given here, will be called as appellant, and the second party will be called as defendant or the respondent. They have to respond. Okay. Now that you've understood, the second case I will give you for interpretation. Now I will give you for interpretation. So again, always when you see this, okay, means what? Complainant in case of criminal cases are always the state government. So state of Maharashtra is the complainant versus Salman Salim Khan. We are talking of 2004 judgment, case which is there of Salman Khan. And it was in which year? 2004. Which journal? So Supreme Court cases, criminal. So CRI is criminal series, you will go, and this is the page number. This is the page number. Concept clear, absolutely. If one, maybe it was just one volume, so that is there. If there would be 2-3 volumes, then they will have to give the volume number also. Okay, in a year, if there are multiple cases, multiple books have been made, so then you will have volume 1, 2, 3. So with this, I can go to the court. I will say in 2004, give me this journal. On this page number, you will be able to find this case law. So this is why it is called as a citation or a reference to any case. Clear? And then there's just a few case, your journal names are there. AIR is very, very famous. All India Reporter. SCC is another Supreme Court cases. SGJ, Supreme Court Journal. These are all various journals. So if you see this name, that means you have to go to this journal on that volume number, that year, that page number, and you will to locate that case law. Okay. So with this, we've covered one part, that is how to read two things. One is a Baer Act. What is a Baer Act and how to read it, and what all preparations you need to do. You need to have a little bit of expertise to understand the Baer Act directly. And second is how to read case laws, also called as citations or references. Clear? That is it, guys. Covered this part. Okay. Now the next part is General Clauses Act. Now pay attention. If someone is asking where is this given, okay, where is this given? Let me tell you. This is in your lesson number 3, interpretation of statutes. These things have been given. These notes which is there, I have shared in the JT community group to all of you all. So then you don't need to figure out. I have summarized everything, covered the past exam questions also out of it. So just go to the community. We have shared these notes there. You can go and study. Which chapter it relates to? Lesson number 3. Lesson number 3, this part has been given. So both how to read cases, and now second part I will be taking you all through GC Act 1897. Sir, is GC Act important? Let me take you through what is there. Okay. So if I can just take you in the past exam, last attempt, June 2025, approximately 10 marks has come from GC Act. So I will be covering the GC Act in this lecture. Okay, so 5 to 10 marks it comes, and I'll be covering it. Okay, let's start. Hi, so we'll be starting with the General Clauses Act 1897. Now, sir, what do you mean by the GC Act and what it is for? So, a General Clauses Act, okay, is an act for common definitions. Is an act for common definitions. What does it contain? Definitions, interpretation, and giving uniform rules for construction. Okay, so you can just remember what is this act for? It gives the common definitions. Like for example, every time you don't have to, in every single act, they don't have to mention that day means this, year means this, immovable property means this. Why? Because if every, let's take an example, a very common definition comes for person, or we can see immovable property. Immovable property. Now what happens? Person or immovable property. Just giving an example. Now if every single act starts defining these things, the act will become so voluminous, so vast. So what did they do? They said, let's do one thing. What we will do is we will have one act called as the GC Act, and all the common general definitions will be put up there. So all the common definitions will be given so that repetitions of definitions in different acts will not be there. If anyone wants to interpret the meaning of this word, they can go and read this. So this is also called as a interpretation statute. Why interpretation statutes? All the definitions can be interpreted here only. Clear? Now remember that prior to this, this is a central law. So it is a central act. So all definitions of central acts are given. So let's say whatever definitions are given here, it applies to all central acts. For example, central act means any law passed by the central government. Common definitions are given in GC Act. State laws, GC Act will not apply. So this applies only to all the acts made by the central government. Now, prior to this enactment, the interpretation in India was governed by the Interpretation Act 1850. This itself is an old act of 1897. Before this, 1850 was there, followed by 1868 and 1887. Now the case law, whenever this act comes, I expect you all to write this case law because the object of the act is given. What the object of the act is given? That in the Chief Inspector of Mines versus KC Thapar, okay, in Chief Inspector of Mines versus KC Thapar, the Supreme Court held that whatever the GC Act states concerning the meaning of the words must be read into every statute to which it applies. Means Supreme Court says that whatever GC Act states, whichever definition they give concerning the meaning of the words, they should be read into every statutes to which they apply. So which they apply? They apply to all central. Simple. We will see when we move forward. Now again, I have told you the object of the act. Let's read it. What is the object of the act? I'm just thinking that it's such a beautiful concept that why every act should define common words. Why not have one act which has all the definitions, so the other acts don't have to again and again repeat it. So to avoid repetition of definition. So the primary objective of the GC Act is to avoid repetition of definitions. Common, uniform interpretation will be there. If I want to know year, so they will mention that year starts from 1st April and ends on 31st March, and calendar year starts from 1st January to 31st December. So if that is defined, then it goes across all the acts of the Central Act. So does it apply to Companies Act? You tell me. Does GC Act apply to Companies Act 2013? Answer is yes. Even Companies Act 2013 is a central act. It applies to whole of India. We don't have Companies Act for every state different. To provide the rules of interpretation of construction, then again we'll be reading what rules are there. That time we'll come to know even that is covered. Now, very, very important, specific versus general. Okay. Now, important, specific versus general. Now let's understand what it means. Imagine the common definitions have been given in GC Act. All the common definitions are given under the GC Act. But let's take for example person. Definition of person has been defined under GC Act. So in all central acts, if the word person will not be defined. Anyone wants to understand, they will go to GC Act. However, Companies Act 2013, let's say Income Tax Act 1961, or now you could say 2025, okay, the latest Income Tax Act, they have separately, though GC Act applies to them, they have a definition of person themselves. Then if IT Act already has definition of person and GC Act also has, then which one will prevail? Which one will be regarded for IT Act purpose? So they said very simple, this is a general act. Only if no definition is given, then you will apply it. But if a specific definition has been given in the act, that only will be referred. So if a specific has been given, then you will refer it. So this is called as specific definition overrides, supersedes general definition. So I call it as specific over general. So let's read what they are saying. That if a term is defined in the GC Act, okay, and it is also mentioned in any special act, then the definition of the special act will prevail based on the rule. Now they've given the rule also in Latin words. General law always is superseded by the special law. Generalia, specialia, non, okay, genealia, no, non derogant. Section 3 says definition. Now see the section 3 only of GC Act. Applies, so all the definitions apply unless the context otherwise require or a special law provides a different meaning. So section 3 of GC Act is saying that this definition applies. Our definition which is given in GC Act will apply unless specific law has already defined. So if specific law is already defined, then we will take that, and this is common sense as well. Okay. Now even if we take another example, okay, let's take another example. Now I'll ask you, now you need to tell me, okay. Now in GC Act, they already have one common word which is regularly used, which is called as immovable property. Immovable property. Now, immovable property is defined under GC Act, and let's say even an act called as Transfer of Property Act defines immovable property. Both are defining it. So, which one will prevail? This is the general law, and this is a special law. So, obviously, if the special law has defined it, we will adhere and apply that particular definition to that particular act. Very, very simple. Now we'll go into the sections and the important sections of this act as well. Okay. First, we'll start with section number 3. Now, section number 3, as they told that section 3 defines many definitions. So all the common definitions has been given, and they have said that if a special law has defined it, then please go as per the special law. These are all general definitions that we have given. Which all they have defined? What is an affidavit? What is immovable property? What is movable property? Oath, will, year. All these types have been defined. Person has been defined. Okay. Now, coming to the, once the first part of the chapter is over, General Clauses Act, that General Clauses Act has certain definitions which are to be applied. But it doesn't end there. General clause is not only about definitions. They also talk about certain rules of interpretation. What do they talk also about? Rules of interpretation. So in some cases, what should be done? That rules of interpretation is also given in General Clauses Act. So let's read and understand. This is from section 5 onwards that we will be seeing rules of interpretation. First, section number 5, commencement of an act. Section number 5 is commencement of an act. An act comes into force from the date it receives the president's assent unless a different date is specified. Very simple, very easy. An act comes into force. So when an act comes into force with effect from. So my question to you is, let's say there is a law, Income Tax Act, okay, Income Tax Act 2025, okay. Just giving an example that Income Tax Act 2025 got the President's approval or assent on, let's say, 1st October 2025. Okay. But the effective date has been given, example is 1st April 2026. Now you all need to tell me that when will the act come into force? So now we'll just read the rules. An act comes into force when it receives a precedent assent unless different date is given. So if a different date is given, then you will take the different date. Then from here the act will come into effect. If no date has been given, then on receiving precedent's assent, the act will be said to come into force. Let's say if effective date is not given, then it is deemed that when the president has given the consent, that is when the act has been passed. Clear? Switch off. Okay. Next. Now section 6 has repeatedly asked in the exam. So this has come not once, not twice, 2-3 regular times they are asking section number 6. Effect of repeal. What happens when an act is repealed? Effect of repeal. Okay. Let's take an example. We know that the IPC, your law of crimes, was repealed. Okay. So your IPC Act, Indian Penal Code, was repealed, and in return we had another act, Bharatiya Nyaya Sanhita, okay, which was passed. So can I say this became the old act and this became the new act? Similarly, let me give you another example. Your Companies Act 2013. The Companies Act 2013, and this became Companies Act 1956. This was the old act and it transited into the new act 2013. So can I say that one act was repealed and another act was passed? So they are saying what happens when it is repealed. So my question to you, if a act has been repealed, replaced, okay, repealed I could say, replaced by a new act, does that mean that all the acts done, rights created, liabilities created, any kind of investigation under the old act will be invalid? Will be ineffective? Answer is no. Very simple, that whatever has happened in the past is valid, and from today onwards, effective date onwards, the new act will apply. So all the past activities, all the past liabilities, rights created under the old act will stay as it is, will be unaffected. Let's read. Logical and very simple also. If any enactment is repealed, if any act is repealed, enactment means act is repealed, the repeal does not revive anything which was not there, does not affect the previous operations. Common sense, everything done in the past will stay as it is. It will not affect any rights, privileges, obligations that it was there. For example, under Income Tax Act 1961, some liabilities were created. So they will not extinguish, it will not affect them. Simple. Because of the new act coming into force. Next, it will not have any penalty, affect any penalties, forfeitures, punishment for acts already done. So all the past will also be valid, and future onwards the new act will apply. Common sense. Any investigations done will be continued as if the new act was not passed only. Means, let's say for example, in Income Tax Act 1961, let's say it is valid even in 2025, and today if some liability is incurred on the assessee and this case goes on for 3-4 years, so act is being repealed and the investigation is ongoing in old act. So will anything happen wrong or will it be invalid? Answer is no, it will be continued. Legal proceedings, investigations, everything will continue as if the new act was never passed, because the offense was done under the old act. Very, very simple. Clear? So as I give you the example, the Bharatiya Nyaya Sanhita repealed the IPC Act, but if an offense was committed on 2024, see this was IPC repealed the IPC from 1st July, before July. In May someone committed an offense, so it is a past thing, and May, June, July, later after 2 months the new act came into force, so the investigation will continue as it is, okay, as though the new act was never passed. Even section number 10 they have asked in the exam. Section number 10 also they have asked in the exam. Let's see what are they saying. Very simple. Now, let's say limitation period is there, that in a certain time limit I have to approach to the court. So limitation period is there for, you know, your civil matters, it is there for some criminal cases, it is there for appeal also they have limitation period. When the consumer case is there, you have to approach the court within a certain time. So let's say if the limitation period is 1 year and on 365th day it ends, okay, and 360 on the last day it ends, but then last day is a holiday, so they say you can take it as the next day. So 1 day grace is given. Let's read. If the last date for completing an act falls on the day when the court or office is closed. For example, on 15th August, national holiday is there. So they say, okay, fine, in the last day the court is closed, then you can take it on the next day, that is 16th August. Or if the last day even falls on Sunday, the same act is allowed to be done on the next day, Monday. Simple. So the act may be done on the next working day. Next, a very simple section number 13 as well. Now section 13 says sometimes the gender is to be disregarded, or what they say, the words masculine gender includes females and singular sometimes includes a plural and vice versa also. So what does it mean? See, when you read any act, the words normally you will see they always mention he, right? For example, in Companies Act, if you see Companies Act 2013 section 164, they say that the director shall not be appointed if he is of unsound mind. So we all know that a director, if he is of unsound mind, he cannot become a director or he cannot continue his post. Now my question is, why are you using the word he? It could also be a female director, women directors are also there. But the law has been framed in a way that sometimes masculine gender is used. But when they are using masculine gender, it means that they also include females. Here, it is due to the drafting purpose that the director should get this if he doesn't get. But they should give he or she. But if they have not mentioned it, because we know that acts when you read, they are all in masculine gender. It includes a female gender as well. Some words which are in the singular includes the plural also, and vice versa. Sometimes, let's say if they say that a law tells you that you have to get the documents to court, it is singular or plural? You tell me. When they say you have to get the document, so it is given in plural, that the accused has to produce the documents within 30 days. Now this documents could also mean a document, a singular aspect also, because possible that he might be having only one document. So they say that just because they have given a plural or singular, you don't have to it is incorporating because the concept is clearly understood. Next, section number 14. What does section number 14 talk about? Let's see. Section 14 talks about the power to adopt, includes the power to suspend also. So normally the appointing agency also has a right to suspend and remove. For example, if the law states that a governor can appoint his ministers, so it automatically, unless the act states otherwise, includes the power to suspend or dismiss. So if you have a right to appoint an employee, it means by default that you also have a power to remove them. Section 21. Now let's read section number 21 also. A power to, what is it saying? Power to issue notifications. A power to issue notifications, orders, rules includes a power to amend, vary and rescind them also. Just like we saw, power to appoint also includes a power to remove. Power to issue laws also means that you have the power to amend and vary the law. So if I go to see all GST laws, who can make the notifications? GST Council. So they also have a right to withdraw it, amend it as they. Then we come to section number 26, offences under two or more enactments. Mark it as important. This also has been asked in the past exam question. So if an act constitutes an offence under two or more enactments, will punishment be given in both the enactments or any one? Or a combined punishment will be given, or once only it will be given? Let's take an example. If a person is having drugs, now for drugs they have a separate, narcotic and psychotropic substances act that is there. Okay, and also you have the Bharatiya Nyaya Sanhita, the criminal law is also there. So a act is punishable in more than two enactments. Let's take another example, terrorism. Okay, terrorism. Now for terrorism also there is a separate act for terrorist that is there, and even the BNS Act is there. Even the BNS Act is there, and plus you might have a dedicated act for declaring a person as a terrorist. So an act may be punishable in multiple legislation, multiple acts, but a person cannot be vexed twice because it is against the constitution. So only one punishment will be given. Okay. So offender may be prosecuted under any of them. So any of them, but should not be punished twice for the same offense. So normally where specific over general will be used. Okay, so wherever you have a specific law, that would generally be used, but he cannot get punished twice. In Baila versus Ranchachari, the Supreme Court held that an offender may be tried under multiple laws, but double punishment is prohibited. It's against the constitution only under Article 20. So let's take an example. Let's take another second example. Someone has done tax evasion. Someone has done tax evasion. So they can be tried under Income Tax Act also, under BNS Act also. Okay. Now because under BNS Act there is a case of theft, and here also you done income tax theft. So then punishment will come under one law only. Okay, specific over general. So under Income Tax Act it will be continued. Next, section 27. Okay. Now what is section 27? Meaning of service of post. Service by post. Now what is the meaning of service? Or normally in civil matters or criminal matters, you call the other party. The court will summon the other party that please come to court and answer the charges. Normally a summon is always executed through the court's officers. Means the court will tell that we want to call the accused or the defendant to court. So court will not dial the number and call them. They will call their officers. They will issue them a summons order and tell go and deliver it to him. Either registered post it will be given, hand delivery it will be given. If he is hiding, if the accused or respondent is trying, whenever we go, they hide or they don't stay at home or they change the address, then a substituted summons will be given. A substituted summons is basically we will go and stick on the wall that this person is there, he tried to evade the summons. So we will stick it on a conspicuous part on the entrance, that on a visible place on his door. Normally you will see in all these someone who are evading tax or etc. Then they try to locate the person but we cannot find. So they go and stick on the entire door the entire order and the summon copy. Okay, so this is what they are given, meaning of summons. So if summons, they will try to give it to the address, they will deem it to give it and try to send it through registered post. Okay, that is very important. Okay, and it will be presumed that if he is not there, we will stick it on a conspicuous part and it has been delivered properly. Okay, a demand notice has been sent through registered post. Very, very important to send it through registered post. Even if the addressee denies it, the service is presumed to be valid. So, or you have to go to the post office and in that registered post you have to give register AD and it goes to their house. So that is concerned as a deemed service, that he has received it. Even if he says I don't want to take it, but he came to know now that there is something and he doesn't want to take it. So it is deemed acceptance, that he has the knowledge. Okay. Now if you go to see the exam questions that have come, they've asked section number 6. Then they have asked section number 26, that a person cannot be punished twice. Double jeopardy is not allowed. Okay. Section number 10 was also there about if on the last date it is a holiday, then the next day will be taken into consideration. Then they've also asked the general, specific over general, and the genelia non-derogant has been given. Okay. With this, we have completed the entire chapter, including the past exam questions and everything given, and that is expected in your exam as well. Thank you. Okay. Till here, I want to know from all of you all, is the concept perfectly clear? Yes or no? I have covered what has come in the past exam in June 2025. All the questions that have come from GC Act I have covered. In December also whatever has come, and I have given the notes in the JT community group. Now I'll be starting with another chapter. Okay, before that, if I have to tell you the chapter wise weightage, okay, chapter wise weightage, you'll get an idea. Okay, so I have completed this part also. In the chat box, let me know if it's clear. Just write the word clear so I know that the concept is knocked off. You don't need to do anything else. I have covered everything, including the past exam questions. Okay. Now I'll be starting off and knocking off another important chapter. Okay. So I'm going to take an important chapter. Pay attention to which one I'm taking. Okay. So if you go back to the chapter wise weightage, now pay attention to which I'm taking. Now in the chapter wise weightage, we have already covered your sources of law. We've covered interpretation of statutes. In interpretation of statutes, they had the GC Act. That also I have covered today. Okay, this is completely done. Now this I have covered. Criminal procedure, the civil procedure code I have covered. Okay, and right relating to this I have covered. Information technology law I have covered. Okay, now which one I will be taking? So first thing is, if you go to see here, very important, which is the most important and short exam question that comes? Can anyone tell me? From here, look at the chapter wise weightage, and I want all of you all to message in the chat box which is the most weighted chapter which confirm comes in your examination. Look into the chapter wise weightage and tell me. I will be covering that chapter. Okay, and when I cover all the past exam questions and everything about that chapter. So the chapter that I will be covering is your Constitution of India, 12 marker chapter. I will be covering your Limitation Act, okay, which is again important. So these chapters I will target. These are big chapters, but I will be covering today. Now tomorrow, again, very good. Everyone is correct. Shriya, great. Kaushika, great. Vaishali, great. Correct. And another thing, if I want to show you now through this, which is the second most important chapter, which all of you all might miss. Let me tell you. Okay, which you all will miss, is the law relating to crime and this Evidence Act. These are collectively called as your three criminal laws. These are called as your three criminal laws. It comes for 17 marks. These three criminal laws I will cover tomorrow in my part 3 JIGL marathon. So approximately 17 marks even today I am covering. So Constitution of India, and I am going to cover today your Evidence Act. Today I'll be covering your Consti. I will be covering your I'll try to cover law of torts also. Law of torts also I will cover, and then one more. Limitation period. Okay. So Limitation Act. Limitation Act I will be covering today. Okay. So this I will be targeting today. So it's a good 20 to 25 marks that I will be covering. Torts, where it is, torts is 5 marks. If I just go into this topics that I'm going to cover, Constitution, then I will be covering your law of torts, that's 17, and then if you go to see your further Limitation Act, so 22 marks I will be covering, and plus I've already covered GC Act, so 25 marks I'm covering in this marathon. So let's start. Now remember one thing, that this particular constitution notes that I have is updated with the latest part. Okay, so it is updated with the latest part what is there. So when I say latest part means what, your in recently only in 2025 for December attempt, some topics for Constitution of India has been deleted. Okay, so that I have factored in. So this chapter that I will be taking will be completely from the new syllabus December 2025 and onwards there. Okay, so just before we start, we will take a 2 minutes or 5-minute break. I'll just request all of you all to like the video and share it with your friends in your WhatsApp, share it with your friends also, because I'm covering so much depth. You will see it cannot be there anywhere in the time that I'm covering, how much I'm covering, all the past exam questions and everything which is important comes. Okay, multiple students have got, yes, it even applies to December 2026. Definitely means December 2025 and onwards. So these are all completely updated. Great. So Constitution of India I'll be starting. Just give me let's say we'll take a 5 minutes we come back. Okay, maybe 5 minutes. We will start with Constitution of. Okay. Till then, I want you all to just revise, go through the GIGL scanners, what questions it is there, and I'll cover the full Constitution of India. Keep a book, pen. It's a big chapter. I'll try to cover it as soon as possible. Okay, so we will be starting with the Constitution of India. Okay, full recap quickly. GTG in the chat box, let me know. Remember, if you even use any notes that you already have, because obviously it's an important chapter, you must have already studied it from someplace. It's absolutely fine. You can refer that. Whenever I'm doing that topic, you can go to that topic and knock it off. My job is to tell you what questions they are coming from exam point of view. So I go through the past exam questions. I know that this is the focus area that they are doing, and my job is to tell you that this is the important thing, and I cover everything in and have heavy focus on the exam questions also. Okay, so that's way you can score a lot more. Here, let's begin. GTG heavy. What about others? Great. You're gonna put that. Keep in line with me. Keep the energies high so that you can easily knock off with me. Let's start. Hi, so we'll be starting with the Constitution of India. Now, before I start the Constitution of India, let me tell you I've gone through the past exam questions, and the questions are in articles that you normally miss out. Those articles they have been asking. So in this lecture, I will be covering everything and also tell you what are the important questions that they have asked from past exam questions, and which is not that important. I will go a little faster but even cover those topics. Now let's begin. The Constitution of India gets its name from the word constitute. It gets its name from the word constitute. Now, what does the word constitute means? It contains the basic rules, regulations of the country. In India, the Constitution of India is treated as the most supreme law. And now, if I ask you a few questions about Constitution of India, maybe you might not know. When was the Constitution of India passed, approved, sanctioned, or in other words, when is the Constitution Day celebrated in India? I want you all to put in the chat box. So if you go to see, on 26th November 1949, the Constitution was adopted, one, and it came into force in 26 Jan 1950. So first thing is, both the dates are important. Which all dates? 26 November. 26 November is treated as a Constitution Day or the Samvidhan Divas. Okay, and in January 26th is treated as Republic Day. Okay, because the Constitution came into India on that day. When the Constitution came into effect, it replaced the Government Raj and the Government of India Act 1935. Now, if you know that the very first Constitution, obviously we didn't have printing, it wasn't in printed form, it was handwritten. It was handwritten by Prem Bihari Narayan Raizada. He had Indian calligraphy, and that is still kept. The first copy is still kept, safe today, and it was asked by the Pandit Jawaharlal Nehru to your Prem Bihari Narayan Raizada to calligraph and write it down. Now, when you go to see the Constitution and the legislative framework of the Constitution, legislative framework means how many articles are there. You don't have sections, they call it as articles, okay, in Constitution. So there are 395 articles. It is divided into 22 parts or chapters, and you have 12 schedules. So 395 articles, 22 parts, and 12 schedules. Now, if you go to see all the parts, let's see the important parts I will discuss. Okay, the very important parts of the Constitution which you can write in the exam also, and which is mostly your exam questions are framed from here. First is your part 3 of the Constitution. Part 3 of the Constitution is your fundamental rights. It is from your Article 12 to 35. Then comes your directive principles of state policy, that is from article number 36 to 51. So part 3, part 4 and part 4a also is your fundamental duties, which is in your article number 51a, and the last important part is your emergency provisions, which are from 32 to 360, which is there. So at least the first 3 parts you can remember, part 3, 4 and 4a. Confirmed question has to come from here. Now, the Constitution, when you open the Constitution of India, it starts with the preamble. It starts with the preamble. I believe already you know what a preamble is. A preamble is an introduction to the Constitution. It contains the objects and the philosophies, or we can say aspirations of the people of India. Okay, it is a brief introductory statement that sets out the guiding principles of the Constitution. So the Constitution preamble consists of an introductory statement which gives the aims, aspirations of people, and it is a guiding principle for everyone. Now, when you go to the preamble, now obviously they don't ask it in the exam, but knowing it is very, very important. And you see that there is a date mentioned here, 26th November 1949. What did we say? What is this date? Because on this date we had adopted the Constitution. Remember we said Constitution Day or Samvidhan Divas is on 26th November 1949. Here we are just done. See, 26th November 1949. First one, 26th November 1949. Came into effect on the Republic Day, that is your 26th January 1950, where we got freedom from the Britishers and British Raj. Now the preamble, if we read, very, very simple, and we've read it in our 10th and school days also, that we, the people of India, has solemnly resolved. So we, that is this Constitution, has been made by the people of India, who have resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, liberty, equality, fraternity. On this date, we hereby adopt and give to ourselves this Constitution. Very simple, that we gave this Constitution to ourselves. We wanted to be sovereign, that is supreme, no British Raj. Socialist, we will work for the welfare state, for the welfare of the society. We will not have any official religion. We will respect all the religions. Democratic republic means we will government of the people, by the people, for the people. Great. Now, before we start about the Constitution, let me tell you some repeatedly. So when we'll be starting, when we are doing this, I'm going to tell you some of the most important questions. Exam importance. Okay. Exam importance. So we will be starting in order of priority only, which repeatedly comes in the exam. So that I will tell you. First, they ask the articles, article 14, 19, 21. These 3 articles are very, very common that they ask. Right to equality, freedom of speech, expression and other freedoms, and right to life. Then they ask something about writs. What are writs? When your fundamental rights are violated, you can go to High Court, Supreme Court and file a petition called as writs. Then you have the structure of the Constitution. So whether the Constitution is unitary, federal, or a combination of both, that is also coming. Then when can Parliament make laws on state list, on matters given in state list? Means when the central government or the union government can make a law for the state. So that will also come, and other importance as we come. But these are the very repeatedly asked exam questions. Let's start with the first article. First article, very, very simple. Now, obviously, you must have done this wherever, whether a law entrance, in your 12th, wherever. but I will tell you the important points so you will be able to build your answer. Right to equality, equality before law, and equal protection of the law. So it states that the state shall not deny to anybody. First, we understand what is Article 14 saying, that the state shall not deny to anyone equality before law and equal protection of the law. Equality of law before law means what? Everyone is equal, nobody gets a privilege. And equal protection means what? Protection means remedy will be given to all. Now, in equality, okay, now in equality, my question is very simple. Does right to equality apply to citizens or non-citizens or both? Does Article 14 apply only to citizens, yes or no? I want to know from you. And the answer is right in front of you. The answer is right in front of you. So if you see this, the state shall not deny to any person means whether he is a citizen or a non-citizen, he can apply under Article 14 for protection. So it applies both to citizens and non-citizens. Now there is a concept called as reasonable classification. Now if you go to see that everyone is not treated exactly equal, some privileges, special privileges are given, but they say that comes under reasonable classification. So that is allowed. You know, for women they have better rights, for children they have better rights, okay. Then for president they have special rules, more safety. So what do they say? Let's see. That a reasonable classification is allowed, because if we don't do that, let's say if a scheduled caste, scheduled tribes, those who are there, they were economically, socially backward initially. So now to give them that benefit, because we want them also to grow, we give them certain special privileges. If we don't do, then it will lead to inequality. So some kind of special privileges need to be given those who are at a disadvantage. We need to bring everyone at the same thing. For that, some amount of privileges can be given. So what do they say that? How do they say that everyone in the eyes equality among equals? If we don't do that, then it will lead to inequality, and reasonable classification is allowed. So first we will write Article 14, then we will write, the two things, absence of special privilege, etc. Then you will write that it applies even to foreigners, that is non-citizens. Then you will write reasonable classification, and then you will start. This line is there. Article 14 forbids class legislation but does not forbid classification. Let's understand what it means. That it forbids class legislation. Sir, what do you mean by class legislation? So Article 14 says you cannot do class legislation, means make a different law for a different class without lawful justification. Okay? Different laws for different people without lawful justification. Common sense, if I make a law without any rationale for any person, then it is invalid. But does not forbid reasonable classification. What does it not forbid? Reasonable classification. Moment you talk about reasonable classification, you say equality equal equals. Same rule cannot apply to unequals, otherwise it will lead to inequality. And then they have told that test for classification, when you can have some kind of special rules made. So the Supreme Court held that the state of West Bengal versus Anwar Ali Sarkar. What did they say? You can quote this in the exam when it comes to article number 14. State of West Bengal versus Anwar Ali Sarkar. They said that it is reasonable classification is allowed only if two conditions are fulfilled. Only if two conditions are fulfilled. First of all, there has to be an intelligent difference between the class which is getting special privileges and the class which is left out. If I see women are given special privilege because we know that they are subjected to violence and atrocities and various issues that women face. So we can give. So we can see a clear difference. Or let's say, for example, a president. A precedent has security issues. That is why it is very important to give them. So there is an intelligent differentia, and there has to be an object which it is trying to achieve. So two things in state of unvalary, that when you're creating special rules for someone, you have to see that there is a logical reasoning and there is an object that we are trying to achieve. Like object could be to uplift women, to uplift the SC/ST, to protect the precedent, etc. So object should be there and intelligent differentia, then it is allowed. Now same thing they will repeat it, okay, in scope of article 14, that permissible classification, reasonable classification allowed. Article 14 forbids this but does not forbid classification. Again, intelligent differentia, object, as we told, mathematical accuracy is not needed, a logical reasoning is enough. Even a single class can be treated as even a single individual can be treated as a class itself. For example, if the president or the prime minister is getting Z class security, so they are one class only, it is fine. That also is allowed and permitted under Article 14. Okay, and whenever anyone is challenging, we will always presume that the law is correct. So presumption is there in favor of constitutionality. Anyone who is challenging that this law is wrong, then the burden of proof is on them to prove why it is wrong. So if a law has been made making a reasonable classification and someone wants to challenge it, so we will always believe that it is correct and you have to prove why it is not correct. Let's take a few examples. Let's take one example of the of exam also. First, I'll tell you one simple thing, like exempting from Sikh from wearing compulsory helmet. So in Sikhs they have to have a kirpan. That kirpan is also allowed normally, which would not be allowed. Now, very important case law, market is important. Okay, now let's see with respect to Article 14 what case law, and it has come in the exam also. It has come in the exam question. So let's mark it as important. Okay, Rajan, okay, held that for valid classification there has to be a nexus between classification made by the law and object it is to be achieved. This we always saw, that there has to be a intelligent differentia and an object to be achieved. State of Anwar Ali case we had seen. Now what did they do? Here let's read. What did they do? A provision for the district-wise distribution of seats of medical colleges on the basis of population was held that it is void. It did not meet the criteria of intelligent differentia. What did they do? They distributed medical seats on basis of population. Now they said, why have to distribute medical seats on basis of population? If in, let's say, a area it is there where people are not interested in studying, still I'm giving medical seats in that area. And let's say there is a population where it is less, everybody is studying hard, but we are limiting them. So they said that they are not trying to achieve anything, and it doesn't look reasonable to distribute just on basis of population. Distribute the seats on basis of merit. What did they say? That it is better to distribute seats on basis of merit. If you are meritorious and in one locality, all should be allowed. So this is what was held. Okay, in P. Rajandhan, a Supreme Court judgment. Then we come to article number 19. Which article we are doing? Article 19. Now article 19 talks about freedom of freedoms which we have. So if you go to see step by step, 6 freedoms are there. Okay, 6 freedoms. And if you go to see this, how many freedoms are there? Let's count. Okay, 1, 2, 3, 4, 5, 6, 7. How 6 freedoms they have mentioned and 7 they have given? A, B, C, D, E, F, G. So right to acquire property as your fundamental right has been deleted by 44th Amendment. Okay, so right to acquire property has been removed. So only the balance freedoms you have. Let's see what freedoms they are there. One by one they start. So let's say there is this person first he is allowed to speak. So speech and expression is there. Then while speaking, he wants to gather, assemble peacefully without arms. There is a person and people are allowed to gather. Peaceful gathering is allowed. So let's say they gathered peacefully. Now they want to form an association. Now they want to form a trade union, association, etc. Okay, fine, association also, that freedom is there. Now they want to move freely with that association. So then we are saying that they also want to move freely throughout the territory of India. Then after moving freely, they want to reside and settle somewhere. So that is also allowed. And the last one is after settling down, then they want to do business. So if you just remember like a story, you will be able to remember all the particular freedom. So right to speech, then assemble, then make a union, then move freely, then reside and then do business. Finish. Now all these rights by default they have given, they are all subject to reasonable restriction. That no freedom is absolute and all the freedoms have a certain restriction. Like you cannot have anything that you do which is affecting sovereignty, security, friendly relations, decency, defamation, incitement of an offense. So all these things are can limit your freedom. So we can say that the rights are not absolute, they are subject to reasonable restriction. Clear? Simple. Now we move each one, then they're given what all restrictions it is there. Similar points you can write. Then you can read Article 19 is the same thing. Then some of the case laws which are there, Hawker Association. The case laws are there, you can just read it once. Hawker Association. So basically Hawker says that we want to stay on the streets and sell, it's a right to do business. So they say no. Supreme Court observes that public streets are by definition for public. No person has a fundamental right to carry on business and create nuisance or annoyance. So hawkers were not allowed to operate. Then there was again a case law of Chintamani Rao versus State of Madhya Pradesh. Chintamani Rao versus State of Madhya Pradesh, they said, remember the word BDs. BD. Okay, so in villages, cigarettes are called as BDs. So what happened that Madhya Pradesh government said that during agriculture season, nobody is allowed to go and make BDs and cigarettes. Everybody is forced to do agricultural work. So they said, what kind of a law is this? You cannot force anyone to do. So it was held that law made by Madhya Pradesh government to not allow people, prohibiting manufacturers from employing people or people to go and work in this is illegal. Okay. Now coming to the next article, that is Article 21. Which one are you doing? Article 21. Very, very simple. It is a right to life. That no person, can you tell me that can we take the life of any person? Yes or no? Can you take the life of any person? A yes or a no? Very good. You cannot take. But so many people are hanged to death is done. Can person's liberty be affected? Yes or no? But so many people are put in jail when they can't move out for many years. So the answer is you can take someone's life also, you can restrict his liberty also, but after a procedure established by law. So now if you go to see this, according to the procedure established by law, no person shall be deprived of his life or personal liberty except according to the procedure established by law. This right ensures that you can make your life meaningful. And right to life includes the right to privacy was given in Karak Singh versus State of UP. In Maneka Gandhi case, they said that a right to life includes the right to move abroad, travel abroad. Okay, and when they say that procedure established by law means what? That they are saying that a procedure has to be followed, like you have a proper hearing, the person got a chance to defend himself, and then he went in, and then the judgment was passed. So right to life is very wide. It includes all the rights including right against custodial deaths, right to live in healthy environment, right against fair trial, even right to adopt was allowed. So I told you these were important articles 14, 19, 21, even 21A. 21A is a right to education, that if you go to see, education is free up to the age of 14 years. So if anyone in India, even the ones on the streets, if they want to go and learn, your up to 14 years, no charges will be done. In government schools, they can go and study. In government, in environmental and this case law, it was held that it is compulsory for the government to ensure Article 21, no fees can be taken. State of Tamil Nadu versus Shyam held that the right of a child should not be restricted only to free and compulsory, they should be extended to quality education. So just they are saying that even the school should be improved and they should be given good education. And now, in the age of technology, in 2019, in Fahima Shireen versus State of Kerala in 2019, it was held that they even should get a right to internet access. Clear? Then these were all part 3 important this we did articles. Now in part 4 or 4A we can say very important is your fundamental duties. Fundamental duties are given in your article 51A. So we always spoke about rights. Now what about the duties? So duties are given in your article 51A. I want all of you all to write it. Okay, article 51A. Now, what are the fundamental duties of a citizen? So, to abide by the constitution, to follow the noble ideas, to protect the sovereignty, integrity of India, to defend the country, to promote the harmony, to preserve the rich heritage, to improve the natural environment, to adopt a scientific temper, to safeguard the public property, to strive towards excellence in all spheres, and try to give the best opportunity to one's child. So, these are all your duties which is there in article 51A. Then I told you very important is writs. Very important is writs. Now pay attention to this. What is writs? I will explain it. That your fundamental rights are given in which part of the constitution? Part 3 of Constitution. When these fundamental rights are violated, or I could say are infringed, or I will say they are aspersed, or they are denied, okay, then what will happen? So then the citizen can go to the High Court or Supreme Court. So then they can go to the High Court or Supreme Court. High Court they will go in Article 226 and Supreme Court they will go in Article 32. Okay, and they will file a petition. They will file a case. That case or that petition is called as a writ. That petition is called as a writ. There are multiple kinds of writs. Okay, 5 types of writs have been given. How many types of writs have been given? 5. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Let's see each one. I will tell you with their main keywords. Habeas corpus, what happens that if someone has been illegally detained by the police, so what they can do? So they can write to the High Court or Supreme Court that please release me, I am an innocent person. So habeas corpus, the court will tell that bring the body, bring the person who has been illegally detained. Why? To check the legality of his detention. If they find that the person has been illegally detained, if they find that the detainee, the person who has been detained has been illegally detained, then the court will order the release of the person. Then they will say that this guy has been wrongly detained, release him. That is habeas corpus. Why you are calling the person? To see the legality of his detention. The object is not to punish the person who has illegally detained another. The object of the writ is not to punish the person who has illegal detained another, but the object of the writ is to secure the release of the person who has been illegally detained. The object is to release persons who have been illegally detained. Simple. Mandamus, always remember we command. Now who is commanding? The court. Now pay attention, okay? Command is by court to public authority. And what they are telling the public authority? To do public duty. Okay. Let's say there is a public authority. Let's say there is a public authority and they are not doing their duty properly. Let's say around you are the roads good? Is water coming properly? Is everything proper? If you feel that any government department is not doing their job properly, go to the High Court, Supreme Court and tell the High Court, Supreme Court, this guy's duty is there, he's not doing his duty properly. Then the court will command the public authority to do its public duty. Now always you see public, public, public. That means in reverse is also true. It does not apply to duties which are private in nature or duties which are optional. Command will only come where they have to mandatorily do any duty. That will only be done. Prohibition. Now prohibition and certiorari is exactly same. Okay. Prohibition and certiorari is exactly same. Let's see what is prohibit. Again, who does it and why? So you have to understand that prohibition means to prohibit. Now who is prohibiting? Higher court. Who is prohibiting? Higher court or high court prohibits lower court from passing erroneous judgment, from exceeding its jurisdiction or its powers and passing erroneous judgment. Okay. Let's say if this bottle has dangerous substance and I am going to drink it. So what will you all do? Sir, stop. So you will prohibit me from doing something wrong. Right? So the higher court will also tell the lower court that we are stopping you from passing an erroneous judgment because you did not have jurisdiction or you are exceeding your jurisdiction, etc. And what if the lower court has passed the wrong erroneous judgment? If a erroneous judgment has already been passed, okay, then the higher court will call for the records of the lower court and squash it and pass their own corrected order. This is very similar to revision in CPC. In CPC also, revision, if you read reference review revision is certiorari. The higher court calls for the records of the lower court to check the legality of his judgment. If it is found that they had exceeded the jurisdiction and the order is already passed, then certiorari will come in, where they will not prohibit. Now you can't prohibit, order already passed. They will then squash it and bring their own judgment. Now quo warranto is basically if any person, let's say the competitive exam is there, okay, they are studying for many years to get a post and they realize that this post has been given to someone wrongly, to politician, his relative, etc. So a person will tell that, listen, I should have got this post, it has been wrongly given to another person, this public office. So again, it is always about an office, any maybe government job, etc. So a public office. So I go and file a court in the High Court, Supreme Court, and listen, my rights has been affected. I should have got this job, but wrongfully this job has been given. So the higher court will call for that record, that how did you get this job by what authority you're holding this public office. They will see whether he got a genuine thing, he has a proper credibility to hold the office, okay, and then he will give. So it is very important that the office is of public nature, like it is created by the constitution, and the other side is saying that he is entitled to the office, and because of that my rights are being violated. So the holder of an office has to show by what authority he is holding the office. Very simple. Now again, very important, then the next one is called as, another important question that they regularly ask is the structure of the constitution. So see, in the entire globally, structure of constitutions are unitary like China, federal like USA, and India has a quasi-federal structure. So what does it mean? That the structure of the constitution, there are multiple structures, types, formats of a constitution. India follows a quasi-federal where they have some features of unitary and some features of federal also. So we are a combo. So let's see what all features we have. So these are the features we have of federal. So our constitution possesses federal features like dual government, central distribution of power is there. Constitution is supreme. The courts are independent, and we have a written constitution and very rigid procedure of amending. So all these are the features of federal which is present in our constitution. Similarly, if you go to see unitary features, now these are all the features of unitary which is there in our constitution as well. So single citizenship, precedence rule, where the powers you see is reunited. One citizenship, one precedence rule in case of emergency. All residuary powers goes to the central government. Judiciary, Supreme Court is also supreme. So all these are features of unitary which are also present in our constitution. So as we saw that we have both the features. We are neither purely federal nor unitary. So we become quasi-federal constitution. Very simple. Then we come to a next important thing which they ask in the exam as well. Very, very important is the power of the parliament to make laws on state list. See, normally central government will make laws only mentioned in central list. They will never go and say that to make the laws which are given in state list, because that the state government will make. But sometimes here what is happening, the government is taking one step forward and thinking, what nonsense, we'll make the law for you. Now when all, very, very important to know. First, in national interest. Now when the states themselves, okay, so the Rajya Sabha passes 2/3 that a law should be made in national interest. So 2/3 of Rajya Sabha are saying that a law should be made by the central government for whole of India. And that matter is mentioned in state list, so still we can make. Now why? Central government will say that you all are only coming and telling me. 2/3 are coming and telling that make a law. Like there was a law which is called as Lokpal. So they want a Lokpal bill to be made, and when the states themselves they write and they say that investigative authority should also be kept independent, they should not report to the government, so that a separate law should be made. So if a law is needed in national interest, then it can be made. It has to be recommended by 2/3 members of Rajya Sabha. Then when a war takes place, a war could also mean a national emergency, external, when a security of India is threatened, when there's an external aggression. So let's see the keywords. When a grave emergency exists, such as whereby the security of India is threatened, there is a war, external aggression, or armed rebellion. So in all these cases, the parliament will also make a law on the state list. Okay. So Article 352 states that if the president is satisfied that a grave emergency exists whereby the security of India is threatened by way of war, external aggression, or armed rebellion, then he will make a declaration that the whole of India, he can make a law for whole of India. Then comes, now remember I will be asking you all these points. So If you remember the headings and the article number, you're good. Rest you can frame it in your own sentence. Breakdown of constitutional machinery. If the governor or if the court feels that a state could not be functioned as per the constitution and there is a failure, then in that case the entire union government can make a law on the state list. In case the government reports to the president that he is satisfied that the government cannot be the current government cannot run as per the constitution, then the president will make a proclamation to that effect. So first of all, governor will go and tell the president that this state is not being able to function as per the constitution, and therefore a proper proclamation should be made that there's a breakdown of constitutional machinery, because of which now the entire control will be in the central government and they can make the laws. Now if two states themselves they go and tell with consent, so then the government will make what problem we have. Two states are themselves coming and saying make a law for us. Next we go to see legislation enforcing international agreements. So international agreements are there. If India enters into any international agreement, obviously all the states are bound. Parliament has a power to make enter into any international treaty and make a law on any whole of India or any part of India. Okay, so 5 points are there. International agreements, two or more states themselves they are saying, breakdown of constitutional machinery, proclamation of emergency by president, and in national interest, 2/3 of the members of Rajya Sabha state that a law being made on national interest. Done. Then another important thing that they ask in the exam is definition of state. So Article 12 defines state. Now what do they say? A state is an inclusive definition. Now you only think what does state mean and why it is important you need to understand. Okay. If there is a person who commits a wrong, you will ask for compensation from that owner. So if a government employee has done something wrong, or let's say there's a car accident, bus accident, you will want to file a case on the state. Now when you can make a party to the state, you need to know that when the state is being covered. So even if the union government is there, or any of the state governments are there, or any of the local authority, or anything which is under the control of government, and they do anything wrong, then case can be filed that this is a state. So state includes all the bodies of state as well. State government, central government, union government, local authorities, everyone, anything that has been made. Like your municipal bodies, trust boards, all of them, because it's funded by government. And there is a very interesting case which they have asked in the exam also. Ajay Hasia versus Majid Khalid Mujib. That how will I come to know that a particular agency or an entity is an instrumentality or the agency of the state? So if I want to know whether the municipal body is considered to be a definition of state or not, so they say very simple rules are there. Does the state control them? Did the state form them? Did the state fund them? Did the state have monopoly rights over them? So is the entire share capital held by the government? Is financial assistance given? Is the corporation enjoying monopoly status conferred and protected by the state? Okay, is there deep and pervasive state control? Are the functions of the corporation, like we could say electricity, now they are very much of public importance, so then that couldn't come in. Is any department of a private organization given to the state? If all these cases are there, then we can say that that department is an instrumentality of the state. Let me ask you a question. Can we say that ICSI, ICAI are instrumentality of states? I want from you yes or no. Yes or no? Very good. They are funded and set up by government. So then yes, they can also be treated as instrumentality of the state. Simple. Now we come to directive principles of state policy. Sir, what do you mean by directive principles of state policy? Let's understand. Very, very simple. Now, the states should direct their policies to achieve these things. So in simple words, you can write that the states should form policies to achieve, you know, part 4 aspiration. Sir, what does it mean? That in part 4, which is directive principles of state policy, the most ideal scenarios have been given: equality of all, freedom of free education for all, good standard of living. Now, these we have not achieved. These they are saying we should achieve. So, all the states should drive their policy to achieve these goals. These are the top notch goals. Part 3 of the Constitution contains the fundamental birth rights, basic rights. These are not the basics, these are the most ideal scenarios. So, nobody can file a case on the court on the government that you didn't give us directive principles of state policies. Why? Because we will try, we cannot achieve it and guarantee it. So, some of them, if you go to see, so these are good guidelines but cannot be enforced in court. So if I tell you that you top in the exam, that is an aspiration, that is a direction, but nobody can put a case on you. But fundamental rights in part 3, freedom of speech and expression, when not given, you can file a case. But directive principles, when not given, you cannot file a case. Simple. Let's see an example. So directive principles of state policy to secure social order, okay, must ensure proper panchayat, human conditions, good standard of living, uniform civil code, free and compulsory for all children up to 14 years. This has been achieved. Okay, some they have achieved, some they have still left to achieve. Simple. Then we come to your article number 20. Okay, let's see what is article 20. Article 20 talks about protection against ex post facto laws. Now, this is also very important. So, I have made the entire constitutional notes in order of importance from exam point of view. So, the first one initially which I did is the most important, and slowly the less important ones or the less repeatedly asked exam questions will come. So, this is also important. Article number 20, protection against ex post facto law. Now, what does it mean? It is simply saying that no person shall be convicted on an offense except if it was a violation at the time of commission of the act. So, when act was committed, that time it should be an, if at that time when I did it was not an offense, no punishment can be given to me. Let's say even I cannot be charged to a higher penalty. So when the act was done, penalty was 3 years. Then the matter went on for years and the penalty increased. Can I get the increased penalty? They say no. No person shall be convicted of an offense except if it was violated at that time, nor can he be, now this is the second part, nor can he be subjected to greater penalty which might have been inflicted at the time of commission of the offense. So at the time of commission of the offense, we'll see what was the maximum penalty. That is the only penalty that can be given. Okay. So ex post facto laws means what? Which are punished when the laws has been done. So you can only be punished if it was an offense when it was done, and you can only get the punishment, maximum punishment, what was at the time of commission of the simple. Now this is article 20 sub article 2, that no person should be punished twice for the same offense. Can anyone tell me, if they've read CPC, which doctrine is this? Double jeopardy. It relates to which doctrine? Quickly. Res judicata. That if person is punished once, then they should not be punished again for the same act. Then comes your protection against self-incrimination. Sir, what do you mean by that? This is article 22, this is article 23, sub article 3. No person can be compelled to give a witness against himself. Like means no person can be compelled to give a incriminating evidence to the cops or the police. Means I cannot be forced to give a statement which goes against me. So police cannot beat me up and tell me, and that even confession before police officer is as it is not valid. Then protection against arrest. Now pay attention to this protection against arrest, what it is. Okay. If a person has been arrested, this is under ordinary law and this is under preventive detention. Let's see. First is under ordinary law. If today a person has been arrested, what is the rules? Can you tell me? Within how much time he should be taken before the magistrate? 24 hours. Okay, excluding the time of journey. So for example, he is being taken from one state to another, then that journey time is excluded. Second, he should be right to defend himself through a legal practitioner and he should be given the grounds for the arrest. So three important rules. He should be told why he is being arrested. He should be allowed to defend himself through a lawyer and he should be produced before the magistrate within 24 hours, excluding the journey time. Now in preventive detention, what happens? That a person has not done any offense and still he is being arrested. Why? To prevent him from doing an offense. Now this could be done to in cases of defense, foreign affairs, security of India. So a person can be detained even when he has not committed an offense, purely on basis of information received or any kind of evidence that we have that he is about to commit an offense. However, there is some protection and safeguards under Article 22 also, that is for preventive detention. First, maximum period he can be detained is 3 months. So let's say if I come to know that this person is a spy from another country, then we can arrest him even before any offense is being committed, and maximum 3 years unless an advisory board has been made and they want to increase it beyond. So maximum 3 months unless a separate board has been made and they are permitting to take, keep him detained for more time. Rest all points are the same, that he should be like above. He should be given legal protection, legal representation. He should be allowed grounds of detention. He should be allowed to be told. Then comes delegated legislation. Very, very important part as well. Pay attention to the concept. If I ask you, I'm explaining the concept, okay? What do you mean by the term legislation? Then you will understand the term delegated legislation. Quickly, what do you mean by the term legislation? Quickly. What do you mean by the term legislation? So legislation means to make laws. Legislation means to make laws. Now, legislative authority, who has the power to make laws? So it is always Parliament. Parliament is main authority, right? Now Parliament makes the main law. For example, they will make the GST Act 2017. They made the law. It has been passed through an act of Parliament. So this is a legislation made by Parliament. Now Parliament cannot make the day-to-day amendments, regular amendments. They make the main law and they leave it. They delegate the powers to a authority. So they cannot make all the laws and amendments. So when powers are delegated, legislative powers are delegated to an authority to make laws, it is called delegated legislation. And that authority makes the law, it is called as delegated legislation. Example, can you tell me that Parliament has delegated to which authority to make the GST changes? It is GST Council. So whenever the GST Council makes a law, it is called as delegated legislation. Because the subordinate authority is making the law. So this is always by the main authority, and this is always by the subordinate authority. Clear? Yes. Let's move ahead to the next one. So why is delegated legislation made? Okay. So one will be a parent act. Act is called as parent act. In the parent act only, powers will be delegated to an authority, and when that authority makes the law, it is called as delegated legislation. Why parliament is not making all the laws? Can you even tell me why parliament is not making all the laws? Because of pressure of work, technicality of subjects, in future lot of emergency situations will come and you require some amount of flexibility. So all these reasons are there. The main authority, Parent Act, delegates their powers of legislation to a lower or subordinate authority called as delegated legislation, delegated authority. Different kinds of delegated legislation, executive legislation. When the police, the persons who are executing the laws aren't allowed to make laws. For example, police can make their own bylaws. SEBI is an executive authority. They have their own SEBI laws. They are called as executive legislation. When the executive is allowed to make the laws. When the court makes the law, Supreme Court also makes law, they are called as judicial legislation. When the municipal bodies make their law, they are called as municipal legislation. When universities, they are autonomous, they operate independently, it is called as autonomous legislation. Colonial legislation, earlier in colonies were there, in UK there are colonies. When each colony is making the law, it is called as colonial legislation. Then we come to another important article, which is called as Article 13. Mark it as super important. Many times they've asked in the exam. Okay, what do you mean by Article 13? So Article 13 talks about Article 13(1), pre-constitutional laws, and they also talk about your 13(2). 13(2) also they talk about, which is about post-constitutional laws after the constitution came into effect. So pre and post constitution is there. So if you go to see, this is your Constitution of India. In which year it came into effect? Everyone tell in the chat box. In which year did the constitution come into effect? 1950, right? All the laws before that will be treated as pre-constitutional laws, and all the laws coming after the constitution was made, as on if today any law is being made, it will be called as post-constitutional. Is the concept clear? Pre and post constitutional laws is covered under which article number? This is under Article 13(1) and this is under Article 13 sub-article 2. Concept clear till here? Yes or no? So any phase, this is prior to constitution, this is post constitution. So for post constitution is very simple because you know the rules today. Okay, so that is very simple. In one line you'll get over. And tell me whether you agree. Can any government make a law against constitution? Constitution is made, so no future laws can be made against constitution. Simple little points. Concept clear? No future laws can be made against constitution. This you also know, me also know. I also know. It is given in your Article 13(2). Article 13(1), let's see what it talks about. It talks about pre-constitutional laws. That pre-constitutional laws will be void to the extent they are inconsistent with constitution. So any law made before the constitution, is it valid or invalid? Any law made before the constitution Contract Act made before the Constitution, na? Sale of Goods Act made before the Constitution, valid or invalid? So they say they are all valid and will be void only to the extent they are inconsistent with the Constitution. So to the extent means only as much part is invalid, that will be void, rest all will be valid. So only that much part that is against the Constitution, only that much part will be invalid, rest all will be valid. From here, they have certain doctrines that will come in. Okay, from Article 13.1. From your Article 13.1, certain doctrines will come. Okay, doctrine of eclipse, doctrine of severability. Okay, these are the two important doctrines that will come from Article 13.1. Let's see. So, Article 13.1, doctrine of severability. Doctrine of severability. Severe means to cut. So they are saying that if any pre-constitutional law, so all this always talks about pre-constitutional law. Okay, if a pre-constitutional law is conflicting with the Constitution, then that much part, to the extent it is conflicting, will be invalid. So when a part is found inconsistent with the Constitution, then that part will be treated as invalid. Now pay attention to this, that if the main part only of the act got invalid, so let's take an example. Let's say a pre-constitutional law was against Consti, okay, and this act had valid portions and they had invalid portion. So what should be done? So the valid portion will stay and the invalid portion will be severed or cut. However, if a significant portion is treated as invalid, major part of the act is only invalid, then what will happen? You will have to throw the entire act. The entire act will be treated as invalid. If the remaining part cannot be kept as independent law and functioning, it will be repealed completely. That is the doctrine of severability. Then when you come to doctrine of eclipse. Now what is doctrine of eclipse? Pay attention. Doctrine of eclipse says that similar, now again same thing, a pre-constitutional, this is also related to Article 13.1, pre-constitutional law. Now imagine a constitutional act was valid. Moment the constitution came, it became invalid. So it doesn't become dead altogether, it is just eclipsed by the constitution. So if this is the act, it was against the constitution. So the constitution came. So does that become dead forever? Answer is no. If the constitutional restriction is removed by an amendment, then this act will be valid again. Sir, can you give example? Yes. This actually can be understood very well with the help of an example only. In Bikaji, Narayan versus State of MP. What happened? There was a law saying that motor transport, government had a monopoly business. So this was absolutely right. Then constitution came and constitution had Article 19(1)(g) that everyone has a right to do business, everybody. So automatically this is conflicting with state monopoly to do business, and then a constitution came and they said that everyone can do business. So what happened? A constitutional amendment was passed that listen, a state can do monopoly business also. So the restriction was removed. So this act automatically became valid. So the act, a constitutional amendment was passed, and this act, which is the Motor Vehicles Act, automatically became valid. So it means that it will be invalid or dormant or dead. So it will be, it's not dead forever. It becomes invalid or dormant is invalid or dormant only till constitution restriction is there. So this act is eclipsed, it is eclipsed by the constitutional restriction, so it is invalid. It is dormant. Moment the restriction is removed, the act will be valid completely again. Then you have a doctrine of waiver. Now pay attention to this. What is this saying? That nobody can waive off their fundamental rights. Waive means to give up. Nobody can waive off their fundamental rights. Now ordinance making power. Now what is the meaning of ordinance making power? The governor also has the power and the president also has the power. Now pay attention to the keywords. Ordinance is a temporary law passed by, for the entire country president can pass, and for the entire state the governor can pass. And why they are doing in emergency? Because parliament is not in session. Parliament not in session. So it's an emergency, it is needed. So president will do it in 123 article and governor will do it under 213. They'll pass a temporary law. Now this also has a time limit. It will only be valid for 6 weeks after the parliament reassembles, unless they have repealed it earlier. So 6 weeks you can remember. So max its validity is 6 weeks from reassembly. So let's say all the parliament session was there. So from that time till 6 weeks only it will be valid, unless they have repealed it earlier. Same for governor, same for president, only the article numbers change. Then comes doctrine of pith and substance. Now pith and substance means the true nature of true character is to be studied. Now we know that, now for this you need to know the case law again. The powers of the governments are divided. The powers of the government is divided. Now pay attention to this. Okay? So you have the list. There are the 3 lists. In list 1, whoever is there, the union government or central government can make laws. Can make whatever is given in the list 2. Who can make laws? The state government can make laws or can legislate. Make laws. So encroachment is not allowed. So what is there by central government only they can do, and they cannot go on state list, and vice versa is in normal cases not allowed. In normal cases it is not allowed. So a proper boundary has been set. Now what happens? It is possible that some things are very much on the line. It is coming here. Like it is touching upon common subjects. Then whether to see which government can make the law, we have to look at the pith and substance of the act. Sir, what do you mean by pith and substance? The essential character of the act needs to be seen. So let's take an example. There was a law which was made on broadcasting. Okay. They said that, listen, now understand. A law was passed by the state government. So the state government, Rajasthan, passed a law that sound amplifiers and loudspeakers should not be used after a certain time because it causes noise pollution and disturbance. This law is there even where you are living. Right? So state government made the law. But they found that broadcasting of sound is in the domain of central government. See, in entry number 81 of the central list, it was written that wireless broadcasting is in their power. So now whether state government can make or central government can make. So then the Supreme Court had to look at the law, and they found that, listen, that the object of the law was not broadcasting purpose. It is to stop noise pollution, and it was coming under public health and not under broadcasting. See, for state government, it had entry number 2 was there, public health. So obviously the loudspeakers which have been made that which should not be used after some time is mostly closer to nature was to public health, and that is why they came to know that the state government can make the law. Then comes colorable legislation. Now colorable legislation is also very simple, but you have to remember the word Kanwar Singh versus state of Bihar. Now, colorable legislation means a deceptive law. What does it mean? It means a deceptive law, that no government shall make a law which is deceptively similar and which disguises itself into legality. So what is cannot be done directly cannot be done indirectly also. So pay attention to what the colorable legislation says. If a government is not allowed to make a law, what do? They color it under some legality that which is under their powers, and they'll make the law. So such kind of laws which are colorable legislation are denied and can be cancelled by the court. Legislature not having power to legislate frames a legislation disguising as if it falls within its powers. So I'll tell you what was a classic example of this. Bihar land reforms case was made, and they named it land reforms. They said that all the unpaid rents by the tenant shall be collected by the state, and only 50% will be given back to the landlord. So what I have said, I'm doing that. I'm trying to help everyone. I'll collect all the unpaid rents and give only 50% back to the landlord. So they said that this is a colorable legislation. You're doing something which you're not allowed to do, that is take away to someone's 50% revenue. So this entire law was cancelled, that you're taking away the entire 50% of unpaid rents from the landlord. You're taking it. So that is disguised, and collecting 100% and returning only half is a deceptive form, and it is not allowed to do it. Then comes plenary powers of legislature. Now again, very simple, means that the constitution grants a legislature the authority to make a law on a particular subject, and if no limitation is mentioned, then it should be read in the maximum possible sense, and they will be allowed to do all incidental ancillary things also. Now let me explain. Plenary powers of legislature, that is etc powers, incidental powers of legislature. If the constitution has granted an authority to make law on a particular subject without restrictions. So for example, if they have made the law has been made that central government can make a law with respect to income tax act, and no limitation has been specifically mentioned in the act, that means it has to be read in the widest possible sense that they have all the powers and incidental, consequential, subsequential to the main subject, means all the surrounding laws also can be made. So if the constitution gives the legislature the power to collect taxes, it is also presumed that they have a power to cancel the taxes, take it back, do all the procedural work and other aspects also. So preliminary means incidental powers. So if you're giving authority the powers without restriction, means they have extreme powers and they can do everything which is incidental, consequential to the main subject, as long as it is not against the act or constitution. Fundamental rights, we've already done this. Okay, 15 to 18 is right to equality. Let's read it. Article 15 is about prohibition and discrimination. So what does it say? That the state shall not discriminate against any citizen on the grounds of religion, birth, gender, etc. Access to public places, no citizen should be subject to any disability because they are from any subject to access the shop, well, restaurants, etc. special provisions can be made if you want women and children to get better employment, better accessibility, etc. So that privileges can be given to economically backward and women and children. Now, Article 16 is similar lines that equal opportunity should be given and states should not deny equal opportunity on basis of gender, etc. But reservations can be made for people living in a certain locality will get preference that is allowed. Women, children, SC, ST can be given special privileges to get employment. Article 17, prohibition of untouchability. So Constitution of India has obviously prohibited and abolished untouchability, and anyone does that will have treated as an offence under law under the Protection of Civil Rights and SC/ST Act, Atrocities Act 1981. So untouchability is abolished, and that is a practice is forbidden in any form. Then comes article number 18. Abolition of titles. So again, earlier state used to give certain kinds of titles. Today it is not allowed because it is leading to inequality. The state shall not confer any title except academic and military. Prohibition of accepting foreign title. No citizen can also accept any title from a foreign state except with the consent of the government, only with the consent of the president. And national awards are allowed. Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, all of that are not considered titles. They are meritorious and it can be accepted. Then Article 19 to 21 we've seen, 22 we've seen entirely freedom of speech and expression and all those. Okay. Then we see amendability of the fundamental rights. So again, very simple. I'll tell you directly. Article 368 of the Constitution talks about amending the Constitution. It says that you can, in Keshwanand Bharti versus State of Kerala. So, moment amendability of Constitution comes, you will write Article 368. You will write Keshwanand Bharti versus State of Kerala. That Constitution can be amended. However, the basic structure of the Constitution can never be amended. Now, what is the basic structure of the Constitution? Secularism, supremacy, sovereignty, writs, your unity, integrity, rule of law. All these factors are treated as basic structure of the Constitution, which can never be amended. Then Article 245. Okay. Scope of law making. The Parliament can make a law for whole or any part of India. State can make a law for any part of the state or the entire state. The government, Parliament, can also make a law which applies extraterritorial jurisdiction. That also they can make. So no law shall be deemed to be invalid merely because it is applying beyond India as well. For example, we make a Indo-Mauritius treaty or we have a separate treaty with Dubai. So the areas are extraterritorial. Even criminal laws are extraterritorial. Any law offense done outside, you can be tried in India. So extraterritorial operations is also valid. Then comes Article 254. Now understand this part, what they are trying to say. Okay. Article 254. Repugnancy between central and state laws. Okay, repugnancy between central and state laws. So if there is a conflict, the first thing is, let's talk matter of education. It comes in concurrent list. Matter of stamp duty comes in concurrent list. Means the state can also make the law and the union can also make the law. So that is absolutely fine. There is no contradiction. Dual laws can be made. Article 254 says that if a state law is inconsistent with the central law, the central law will prevail. So first thing is concurrent is both the governments can make the law. But if there is a conflicting, then the central law will be prevalent. Then we know that we have the Supreme Court High courts are there in each state. Supreme Court is the most supreme body. Separation of powers. Now again, very simple. What does separation of power mean? This we always know. That we have done it in our civics in 10th. That our country has three important bodies, that is legislature, executive and judiciary. Judiciary are the courts, executive are the ones who implements the law, and legislature make the laws, parliament. So all of them are independent. There is no article in entire constitution which says that the division of power should be done, but from the roles you can identify that separation of power is there. There is only one article which says that the state shall take steps to separate the judiciary from the executive. So Article 50 is only one article which says that judiciary should be kept separate from the executive. So we all know that courts are separate, they operate independently, they are not reporting to any executive. Then law making process in India. So very simple, we know that first any law, now if any law making process comes, the power of the parliament to enact the law is derived from Article 245 and 246, which authorize the parliament to make for any country the entire law, and the state can make for the state government can make for the entire state. Article 245 and 246. A bill is normally introduced. So we know the income tax bill, company law bill. Okay, first the law making process, when a bill is introduced in either houses of the parliament, money bill is always introduced only in Lok Sabha. Financial matters are directly introduced only in Lok Sabha, whereas any other bill can be introduced in any part, any bill first, in any house first. 3 readings are needed for each house, in each house. So a bill must undergo 3 readings. First reading is to understand, second is to go more detail, and third is to hold a final discussion. So first a bill is introduced in any of the houses, then 3 readings are done. Then after passing from each house, it goes to the President's assent under Article 311. Then the bill becomes an act. Once the President gives the assent, the bill becomes an act and it acquires legal force and it is come into. So bill, 3 readings, then both the houses pass it, then the President's assent, and then it becomes an act. Then we are going to see one other thing, which is trade, commerce and intercourse in India. Okay, now we are going to see Article 301 to 305. 301 talks about freedom of business and 305 tells the restriction. So 301 is saying that you can do business wherever you want, and 302 to 5 talks about the various restrictions. Let's see. Trade, commerce and intercourse. Okay, so Article 301 talks that the Constitution provides that the trade, commerce, intercourse in the country should be free throughout the country. So again, first one is they are saying that Constitution provides that movement of business, I am allowed to do business in any part of the country. So any unlawful trade is not protected. Means if they are saying that I am free to do any business, doesn't mean now I can do business of drugs, which is illegal. So illegal drugs obviously is not allowed. Object of the law is to say that the Constitution ensures unity of the country, that anyone who wants to do business anywhere can do it. While freedom is there, it does not mean that the state is barred from completely regulating the aspects, taxes, etc., octroi and all those taxes which are there, entry tax, they want states could introduce. Now coming to 302. Now 301 was about you can do the business. Here also one illustration was there which had come in the exam, that a person cannot challenge the levying of toll tax saying that freedom of business is given. So that tax, though there is free movement of goods allowed, that means that you can move the goods subject to the payment of taxes and procedures to be followed. 302, 345 talks about restrictions, that impose restrictions. Parliament may impose restrictions as they deem fit. 303, no discrimination should be done by the states, and restriction on the trade legislature may make a law restricting import of goods or some reasonable conditions as they want. And 305 says that, very important point, okay, 305, that monopoly can be created, that time you cannot demand that you have a right to business. Article 305 says that the freedom of trade and business does not affect the existing laws, and the law means law that creates state monopolies. So Article 305 says the freedom of trade and commerce under 301 to 304 does not affect the state monopoly. So if a state has a monopoly, then you cannot demand that you want to do business. Here, with this, we have completed the entire Constitution of India, including the past exam questions and all important topics. Thank you so much, guys. Okay. So everything has been covered nicely. You study this, your constitution is genuinely done. Told you all the points. Your job is to write all the important points which I have told you. Okay, it's also my request, do like the video, share it with your friends. Many students don't know that like English lectures are there, especially those who are from the South India. Please share it in your groups, give a shout out, because it's you only who can help us reach the students and your friends, because they are hunting for lectures in English. And you will see them almost no YouTube channel. We are the only YouTube channel which has taken marathons for in English for all the three levels. Okay, great. Do you provide one-on-one classes? So obviously we have lectures, in that we have Zoom sessions, everything, and to the students we help them and guide them individually also. Okay, the guidance is there, obviously. You don't have to worry. Now I'm just looking, we'll start with one more other topic, which is Limitation Act. Let me see here. Limitation Act. We will start after the break. Okay, so we'll take a short break and then we will start with Limitation Act as well. Till now, request all of you all to like the video, share it with your friends. This at least you can do it on my thing, because reaching out to all of you all is very very important. We're putting in efforts, but it's your job to reciprocate and let us know whether we can help you. Comment and motivate us also. We keep motivating you all also have to keep motivating us. Okay, we'll take a 5-10 minutes break and we will come back. Okay, and then complete it. So we'll take a break and complete this entire chapter in depth. So 10-minute break we can take and complete. Okay, so that is it, guys. So I can start by 7:40. Hello. Hi guys, am I audible and visible to all of you all? Please let me know in the chat box so we can quickly start and complete this chapter for you. Just let me know GTG in the chat box. GTG in the chat box so I can quickly start and complete. Okay, great. Great, so let's begin. Hi, so we'll be starting with the chapter called as Limitation Act 1960. Now, what do you mean by the term limitation? So, in every matter in court, law prescribes a time limit. Within that time limit, you have to approach the court if you want to file any suit, application, or appeal. You cannot come after the time limit and then expect the court to take up your matter. So, the time limit prescribed under law is given under Limitation Act 1963. Now, the question comes that why put a time limit in the first place? If something wrong has happened, I can approach the court after 100 years also. Why the court should not give me justice? So, the reason is very simple that with time, the evidence fades, it causes harassment to the other party, and third, law wants to help the vigilant who are aware and who takes action immediately, and not those who are indolent and sleep over their rights. Now, let's begin with the section. I told you the act, the object of the act as well. Now, let's look at section number 3, bar on limitation. So the bar is a restriction made by the act that courts only should not entertain an matter if someone is coming after the limitation period. So section 3 starts off saying that the courts should not entertain or take up a matter if the SAA is filed beyond the time limit. The suit, application or appeal. They are saying, second line, that the court only bars the remedy, does not extinguish the right. Sometimes they say, what does this mean? So court is saying that we are barring the remedy. In courtroom, we will not give you any relief. You came after the time limit, sorry. However, we are saying that you are entitled to remedy. Do it on your own self now. So if anyone can recover out of court through out of court settlement through any other ways, they are entitled legally to achieve it. So what does it mean? The sentence that the courts bars a remedy. Court will not give the remedy. But the right is always there, so you can get a remedy from any other person. You can negotiate, you can appoint an arbitrator, you can appoint an intermediary and try to settle it out of court if possible. If not, court will not help you. So we can say that the court only bars the judicial remedy. All other remedies you can try. Second, section 4. If the court is closed on the last day of the limitation period, so very simple, don't worry, you can come on the next day when the court reopens. So if the last day of the limitation period is a Sunday, you can come on the next day and file the suit. That is the one benefit given. Now section number 5 talks about extension of time in certain cases. That means if for sufficient reasons, like someone is unwell, someone's parents is unwell, and many times in law and when you are reading the law, you will also see that if the court is satisfied that there is a sufficient cause, extension of time can be given. So doctrine of sufficient cause says that if a party has a sufficient cause, then the time limit and the extension can be given and the delay can be condoned. The delay can be pardoned. Okay. Now when all court has accepted it, sometimes when you have filed a case in another court, if a wrong advice has been given by the court, the party was in jail, imprisonment, there was illness of themselves or the parties. Now each case has to be studied independently before granting this extension of time. That is, it is an individualistic test whether really this party could not come or they are just fooling the court. Then we are seeing section number 6, very very important, legal disability. That when the cause of action arose, means when the wrong happened, the person was in a legal disability, was under a medical condition or was a minor, then can we start the limitation period? Let's take for example, one person is there, okay? Now this person has a medical reason, medical issue, or this person is a minor. When wrong happened, or I could call as a cause of action happened. Now logically, when the cause of action happened, this person is incompetent, legally disabled to file an application in court. So should we start the time limit according to you? Should time limit be started? Yes or no? Obviously not. The time limit should not start. The time limit should start, period of limitation, period of start, when the disability ceases. If someone cannot move, how you can start his time limit? Or if someone is a minor, how you can start his time limit? The time limit will only start if the legal disability ceases to exist. If the legal disability continues up to death, the person died only, so then the legal representative, from once the legal representative is appointed, that time the time limit will start. Now if let's say it was a joint property, and on a joint property something wrong has happened and both the parties are in legal disability, so should we start the time limit when both are out of disability, or any one is also out of disability? We should start the time limit. We are talking of if multiple plaintiffs are involved, and in multiple plaintiffs are involved, and in multiple plaintiffs any one also came out of a legal disability. So this is start the time. We can't wait for too long. So first point is, if several persons are under disability, when any one person also come out of disability, then we will start the time limit. Now once the time limit starts, once the period of limitation start, no subsequent disability or inability will stop the time. What does this mean? Once he was competent to file the case and then later he fell ill, it is not going to be started, because once that we start the time, then we will not take. All the above cases where we were not starting the time only because the person was under legal disability. But if a person is extremely fit and competent and he could file a case, and let's say after a few years he went into legal disability, we will not pause the time, it will continue. So this is called as section 9, continuous running of time. Once the period of limitation starts, no subsequent disability or inability can stop it. Now exclusion of time in legal proceedings, very very simple. Section 12 says, in computing the period of time limit, the date when the cause of action arose is to be excluded. For example, if the rights was broken on 1st October, we will not start the time on the day when the cause of action arose. We will start your time from the next day. Simple. Similarly, all the other points are also same. But let me tell you what is the point, okay? If the time limit to obtain the copy, the time limit to obtain the copy, the time limit of obtaining the judgment copy, or the time limit for obtaining the award. So if any particular, all these 3 points are similar, okay? Pay attention. First we'll just finish appeal. That for an appeal, the leave to appeal, the day when the judgment was complained. Okay, so all the things, whether it is an appeal or any other case. Now pay attention. The order was given So three cases they have put. All the points have same things. Okay, whether it's an appeal, or whether it is a decree, or whether it is a appeal, whether it is a award. In all these cases, whether you're going in appeal or decree or award, the time limit to obtain copy will be excluded. Okay, so let's take for example, I made an application for the award copy, the award or the decree or the appeal, and court took 7 days. So can I start my, if I want to go in appeal or I want to complain against a decree or a award, can I go in appeal if I don't have the order copy? Answer is no. So if I make an application, then from that time, how much ever time the court takes time to give it to me, that much will be excluded. Only when I have the order copy in my hand, then my time limit should start. Simple. Then comes section number 16. Okay, very simple. That effect of death, okay, on the right to sue. What did we say? That if a person died, we will start the time limit when the legal representative is there. But if the legal representative is also under legal disability, so we will wait till the disability ceases. For example, a person died, now his child should take forward legal representative. But let's say child is minor, so we'll have to wait till he becomes a major. Let's read the provisions. In case of death of a person, before right to institute accrues, the period of limitation shall be computed when the legal representative is capable of filing the suit. So what they are saying, that the period of limitation shall be computed when the legal representative is capable. So here in one case what happened, that the person died and he was left with only one child and nobody else, and the child was also minor. So till the legal representative doesn't become capable, we will not start the time limit. Then there are two things: effect of acknowledgement of debt and part payment. Okay. So effect of acknowledgement of a debt and part payment, both of them. Now just remember, if I make a part payment, means I'm acknowledging my debt, that there is a debt. So both of them have the same provisions only, that if there is an acknowledgement that yes, I have to pay you, or take this part payment, that means I have to pay you, a fresh period of limitation will start from the date of acknowledgement or from the date of part payment. Why? Because a fresh piece of evidence is being created. So whenever there is an acknowledgement, that is an admission of a debt, or there is a part payment, from that date a fresh period of limitation will start, because a new piece of evidence is generated. If any person acquires any property for acquisition of ownership by possession, so if for 20 years you are having undisturbed, without interruption, you are having peaceful enjoyment of a property, the property you become the owner through adverse possession. If it is government property, 30 years if you have adverse possession without interruption, peaceful enjoyment, then the person becomes the owner. Now one very important point, okay, very important point, does period of limitation apply to writs, like say writ petition? Is there anywhere in Constitution of India you read that you have to appear before the court in a certain time? Answer is no. So does limitation period apply to writs? Answer is no. Now understand that writs are fine when your fundamental rights are violated, and fundamental rights have to be given. So if a law has been passed which is against your fundamental rights, you can go any point of time. Simple. Okay, limitation period does not apply to proceedings under Article 32 and 226. Okay, under Article 226, there is no time limit for filing a writ petition. However, courts have made a rule that within reasonable time you should come. Okay, and a little bit of delay can be allowed, but courts will always look at the limitation period and see that why didn't you come within this much time period. So that reasoning will be there. However, it cannot be denied. But if the court finds that unnecessary and it is frivolous case, they can deny it. So what is the rule? Initially, no time limit is prescribed. However, courts have made a rule that they will look at time limit and see whether they should permit it or not permit it. If it's a frivolous, vexatious or a fake claim, they can reject it. Then the time limits has been given, the schedule has been given, okay, all this. But if you take this summary, you will come to know. Mostly, now pay attention, time limit has been given. Now, how much is the time limit is related to property matters, related to movable property? How much is the time limit is related to other things? Let's see. Period of 30 years has been given if it is obviously related to three kinds of suit only. Immovable property, okay, if a suit is being filed on basis of government, and again it is immovable property, okay, here. So suits by mortgagers and suits by mortgagees is 30 years. Means what? Mortgager is a person who has borrowed the money. So if I feel that the bank is not giving me the house back after paying them also, I will have to file a case within 30 years. Mortgagee is the lender. If the lender realizes that you have not made the payment, then they will have to go to the court and foreclose it. So mortgagee makes a foreclosure, means they want to close the loan, that money was not paid, I want to sell the property and get it. So 30 years. Suits on by and behalf of government is 30 years. Other matters of property are under, apart from these three, are 12 years. Property with respect to declaratory suits are 3 years. 1 to 3 years if it is related to other miscellaneous matters. And again, period varying between 90 to 10 days, okay, is in case of summary matters, okay, summary. With this, we have completed the entire chapter, including all the exam questions and the important sections. Thank you so much. So we are concluding the marathon today. I have covered heavy topics today. Okay, and tomorrow I will see the other important chapters and complete it. Now it is my request to all of you all, just like the video, it doesn't cost you any money, this motivates me. Share these videos with your friends, okay, because you know everyone who's attending these marathons, they get exemption. I have also got an exemption, and you will open your books, you will see everything is being covered. I have given you the past exam questions and the answers that is available on the website in free resources section. And two more gifts are coming up very soon with for all of you all. One is about test series and the other one is about dream batch. So do share it with your friends, especially students from South India and students from Mumbai. Okay, we are having this face-to-face session in Mumbai Andheri Center also. So if you can make it to the Andheri Center, do come. And if you can sit online, do sit for all our marathons. In short time, I cover maximum possible things and all past exam questions. With this, I sign off and thank you all so much. Do like the video, share it with your friends. That's your return to me. Thank you guys. All the very best. See you tomorrow for the marathon. Thank you everyone.